The first deputy had his hand resting on his holster when the president of the HOA pointed straight at me and said, "That's him. That's the squatter." I stood beside the weathered white fence my grandfather had repaired before I was born, staring at 3 sheriff's vehicles parked across my gravel driveway. Behind them, a tow truck idled beside an HOA security SUV, and behind that stood Vanessa Whitmore, president of the Briarwood Estates Homeowners Association, holding a leather folder against her chest like she had already won. "Mr. Mercer," the deputy said carefully, "we received a complaint that you refused to vacate property belonging to Briarwood Estates." I almost laughed. Almost. Instead, I looked past him at the red farmhouse sitting beneath 2 enormous oak trees. "My family has owned this land since 1927. Vanessa stepped forward. "That's what he keeps claiming." I turned toward her. She was wearing dark sunglasses despite the cloudy morning, and there was a small, satisfied smile at the corner of her mouth. "Claiming?" Vanessa opened her folder. "You've been given multiple notices, Mr. Mercer. The county parcel maps clearly show this property falls inside the Briarwood development boundary." "No," I said. "They show your development ends at my eastern fence." Her smile disappeared. "That matter has already been settled." "By whom?" "The HOA's attorneys." I stared at her for a second. Then I said, "Your attorneys don't determine who owns land." One of the deputies shifted uncomfortably. Vanessa's voice sharpened. "You were given every opportunity to cooperate. Instead, you threatened our survey crew, removed HOA notices, and refused access to authorized personnel. I told 3 strangers they couldn't cut the lock off my gate. They were authorized, not by me." Vanessa looked at the deputy. "You see what we've been dealing with?" That was when the 3rd sheriff's vehicle rolled slowly up the road. Vanessa straightened. Finally. The driver's door opened. Sheriff Thomas Reed stepped out. He was a broad-shouldered man in his late 50s with silver at his temples and the kind of expression that made conversations stop without him saying anything. Vanessa hurried toward him. "Sheriff Reed, thank God. We need this individual removed immediately." Reed barely looked at her. His eyes had already found me. For 3 long seconds, nobody spoke. Then something completely unexpected happened. The sheriff smiled. He walked past Vanessa, stepped through my open gate, and tipped 2 fingers toward the brim of his campaign hat. "Good morning, Judge." Vanessa froze. The deputy beside me slowly removed his hand from his holster. I watched every trace of confidence drain from her face. "You," Vanessa whispered. I hadn't heard anyone call me Judge Mercer since I'd retired from the county bench 3 years earlier. Sheriff Reed shook my hand. Then he looked toward the tow truck. "Would somebody mind explaining," he said quietly, "why we're attempting to remove a retired Superior Court judge from land his family has owned for 99 years? Vanessa's mouth opened. Nothing came out. But what she didn't know yet was far worse, because folded inside my jacket was a document dated 1927. And according to that document, the HOA wasn't trying to steal a few feet of my property. They had built nearly half their neighborhood on land they might never have legally owned. My name is Daniel Mercer. I was 61 years old when Briarwood Estates decided I was a stranger on my own land. For 27 years, I served the courts of Ashford County, Virginia, first as an attorney and eventually as a Superior Court judge. I retired 3 years before this mess started, mostly because I'd grown tired of spending my days listening to people argue over things they should have settled with a conversation and a little common sense. Ironically, retirement brought me the biggest property dispute of my life. The Mercer Farm sat just outside the town of Hawthorne, on 68 acres of rolling pasture, hardwood trees, and red Virginia soil. My great-grandfather, Samuel Mercer, bought it in 1927. The original farmhouse was still standing, so was the stone well behind the barn. As a boy, I'd spent summers there with my grandfather, Henry. He taught me to repair fences, sharpen tools, and never make promises I couldn't keep. Whenever we walked the property line, he'd tap one of the old stone boundary markers with his boot. "Land remembers," he'd tell me. "People forget, paper gets lost, but land remembers." I used to think that was just something old men said. After retirement, my mornings became wonderfully predictable. Coffee at 6, feed my 2 horses, walk the eastern fence, then breakfast on the porch with my golden retriever, Murphy, stretched beside my chair. Briarwood Estates had been built east of us about 8 years earlier. It was a polished development filled with stone front houses, identical mailboxes, landscaped entrances, and enough neighborhood regulations to govern a small country. For years, we had no problems. Then Vanessa Whitmore became HOA president. The first sign of trouble appeared on a Tuesday morning. I found a bright orange notice stapled to my eastern gate. Briarwood Estates, HOA, property compliance violation. I read it twice. Apparently, my wooden fence violated community appearance standards. I called the number printed at the bottom. A woman answered. Briarwood Estates Management. This is Daniel Mercer. Someone attached a violation notice to my gate. There was keyboard tapping. Yes, Mr. Mercer. You have 14 days to correct the fence. I don't belong to your HOA. Pause. Then she said, according to our updated property records, you do. I leaned against the kitchen counter. Updated by whom? I'd have to refer you to President Whitmore. The next morning, another notice appeared. This one demanded removal of my equipment shed. 2 days later, I found fluorescent survey flags planted 20 yards inside my pasture. I pulled them out. That Friday afternoon, Murphy started barking toward the eastern field. I stepped onto the porch and saw 2 men in reflective vests standing beyond my fence. One held surveying equipment. The other was driving a wooden stake into my soil. I crossed the field. Can I help you, gentlemen? The older man looked uncomfortable. We were told this property belongs to Briarwood. Who told you that? Before he could answer, a black SUV rolled up beside the fence. Vanessa Whitmore stepped out. She looked directly at me and said, Mr. Mercer, you need to stop interfering with HOA property. And that was the moment I realized those notices hadn't been mistakes. I stopped about 10 feet from Vanessa. The surveyor lowered his hammer. You're standing in my pasture, I said. Vanessa shut the SUV door and adjusted the cuff of her cream-colored blazer, as if we'd met for a business appointment. No, Mr. Mercer. They're standing inside Parcel 18B. I don't own anything called Parcel 18B. That, she replied, is precisely the problem. She pulled several papers from a folder and extended them toward me. I didn't take them. What are those? Updated boundary records. County records? Records prepared for the association. That wording caught my attention. Prepared by whom? Our legal team. I glanced at the surveyors. Gentlemen, did the county authorize you to enter this property? The younger man looked at Vanessa. She answered for him. They don't need your permission. They absolutely do. Her jaw tightened. Your deed is outdated. For the first time, I felt something colder than irritation. Deeds don't expire because an HOA dislikes them. Vanessa stepped closer. Briarwood's title review established that approximately 11 acres you've been occupying were incorporated into the development tract during a boundary consolidation. Show me the recorded instrument. Her expression flickered, only for a second. You'll receive everything through counsel. Then until I do, everyone leaves. Vanessa laughed softly. You don't get to order us off HOA land. I just did. The surveyors packed their equipment. Vanessa watched them retreat toward their truck, her face turning red. You're making a serious mistake. No, I'm preventing one. The following Monday, a certified letter arrived, demanding $18,600 in accumulated HOA assessments, penalties, landscaping violations, and legal expenses. I called Vanessa. She answered immediately. You received our notice. I did. Explain $18,600. You've benefited from Briarwood infrastructure for years without paying assessments. I have my own well, septic system, driveway, and county road access. That isn't relevant. It'll become very relevant if you file this. Her voice became quiet. Mr. Mercer, sell the disputed acreage to the association. We'll waive the balance. There it was. Not compliance. Not neighborhood standards. Land. How generous. We're offering you an opportunity to resolve this privately. You're demanding 11 acres my family has held since 1927. We're demanding property you cannot prove you own. I stared through my office window toward the eastern pasture. I suggest you verify that statement before repeating it. She hung up. 3 nights later, someone cut the chain on my eastern gate. My security camera captured an HOA-marked utility vehicle entering at 11:43 p.m. The next morning, I found fresh stakes running across the pasture. One stood less than 50 yards from my house. Then came the document that changed my concern into alarm. A process server handed me a petition alleging unlawful occupancy and requesting immediate possession of the disputed acreage. Attached was a map I'd never seen before. My farmhouse itself sat inside the shaded area labeled Briarwood Estates, HOA-controlled property. I studied the recording number printed beneath the map. Something was wrong with it. Very wrong. because I recognized the year. The supposed boundary transfer had been recorded in 1998, and the man listed as signing away the Mercer property was my grandfather, Henry. There was only one problem. My grandfather had died in 1994. The moment I saw my grandfather's name on that document, I stopped thinking like a homeowner. I started thinking like a judge again. For 3 decades, I had sat behind a bench and watched people try to manipulate facts. Some lied with confidence, some hid behind paperwork. Some believed that if something was typed on official-looking documents, nobody would question it. But every case came down to one thing: proof. I placed the document on my desk and stared at the signature line, Henry Mercer. The handwriting looked close enough to fool someone who didn't know him, but I knew my grandfather's signature. I had seen it thousands of times, on birthday cards, on farm equipment receipts, on the original family trust documents. This wasn't his signature. Someone had copied it. The next morning, I called the one person I trusted to examine this without emotion, Margaret Collins. Margaret had worked as a real estate attorney in Hawthorne for nearly 30 years. She was also one of the few people who could tell me I was wrong and make me listen. She arrived at my farmhouse carrying a leather briefcase and wearing the same serious expression she had during every difficult negotiation we had ever handled. She placed the HOA documents on my kitchen table. "Daniel, before I say anything, I need you to understand something." "What?" "Your reputation doesn't matter here." I nodded. "Good." She opened the folder. "The court won't care that you were a judge. It won't care that your family owned this land for generations. It will only care about recorded evidence." "I know." She looked at me. "That's why this worries me." For the next 3 hours, we examined every page. Old deeds, county tax records, survey maps, HOA filings. Margaret pulled up the county database and searched the recording numbers. Her eyebrows slowly narrowed. "That's interesting." "What?" "The boundary consolidation document was recorded in 1998. "Yes, but the survey it references was supposedly completed in 1997. "Is that unusual?" "Not by itself." She clicked through another file. "But this survey company didn't exist until 2001. The room went quiet. I looked at her. "So the survey referenced in their legal paperwork didn't exist when the document was created?" "Exactly." Margaret printed several pages. Then she searched the county archive for the original Briarwood development approval. A few minutes later, she leaned back. "Daniel." The tone of her voice made me sit up. "What did you find?" She turned the monitor toward me. "The original development plan showed Briarwood Estates ending exactly where my eastern fence stood. No overlap. No disputed acreage. No shared boundary. Nothing." "They knew," I whispered. Margaret shook her head. "Not enough yet." She opened another file. "Look at this." It was an email chain between Briarwood's original developer and an outside survey consultant. The subject line read, "Potential boundary issue. Mercer tract." The email was dated 2 months before construction began. I read the first sentence. "The Mercer family property creates complications with planned expansion. Recommend resolving title concerns before proceeding." My stomach tightened. They weren't discovering a mistake. They were discovering a problem they built around anyway. Margaret continued scrolling. Then suddenly, she stopped. "Daniel." "What?" She enlarged an attachment. It was a scanned county map. At the bottom was a handwritten note from a former county surveyor. Only 6 words, but those 6 words changed everything. "Never approved, never transferred, never sold." Margaret looked at me. Someone inside the county knew this entire time. And then my phone rang. The caller ID showed an unknown number. I answered. A nervous man's voice whispered, "Judge Mercer, if you found that map, you need to know something." I stood up. "Who is this?" The man paused. Then he said, "They're not trying to take your land because of a boundary mistake." A cold feeling moved through me. "Then why?" His voice dropped. "Because your property is the one thing standing between them and a multi-million-dollar development deal." The call ended. And for the first time since this started, I realized Vanessa Whitmore wasn't fighting me over my farm. She was fighting me because my land was worth far more than anyone had told me. The anonymous call changed everything. Until that moment, I believed Briarwood Estates had made a reckless mistake and was trying to cover it up. But now I understood. Mistakes were accidental. This was intentional. Margaret and I spent the next week digging through every document we could find. We contacted retired county employees, reviewed archived planning records, and requested copies of development agreements that had been buried for years. The deeper we looked, the worse it became. Briarwood Estates wasn't just a neighborhood. It was the first phase of a much larger project called Briarwood Commons. The plan included luxury townhomes, a private clubhouse, commercial buildings, and a small shopping district. And the missing piece, my land. The original proposal showed a road extension cutting directly through my eastern pasture. My property was the final connection point between Briarwood and the highway. Without it, the entire expansion plan lost millions in projected value. Margaret sat across from me in my office, reading through the documents. They didn't want your 11 acres because they cared about landscaping violations. I looked up. They needed access, she nodded. And they needed a way to make your ownership disappear. That was when we found the document that became the foundation of our case. A recorded easement agreement. It had my grandfather's name, but unlike the forged boundary transfer, this one had something different. A notary stamp, a witness signature, and a filing date. Margaret looked confused. Wait, what? She compared the dates. The easement was supposedly signed in 1998. Yes, but the witness listed here was dead in 1996. I felt my hands tighten. They didn't just forge one document. No, Margaret said quietly. They built an entire paper trail. Before we could continue, my front gate camera sent an alert. Someone was outside. I opened the footage. It was Vanessa. She stood at my gate with 2 HOA board members. A crowd had gathered behind them. Neighbors, residents, people filming on their phones. Margaret looked at me. They want a reaction. I know. I walked outside. Vanessa raised her voice before I even reached the fence. Daniel Mercer, you have repeatedly refused to cooperate with the association. The cameras immediately turned toward me. I stayed calm. You broke into my property. That is false. I have security footage. Her smile tightened. You continue spreading accusations against Briarwood Estates. I have documents. The crowd became quieter. Vanessa stepped closer. You should think carefully about what happens next. Is that a threat? No, she smiled. It's advice. I looked around at the neighbors watching. For the first time, I saw doubt on their faces. They had been told I was an angry old man refusing to follow community rules. They hadn't been told about forged signatures. They hadn't been told about hidden development plans. Vanessa lowered her voice. You spent your career in a courtroom, Judge Mercer. You should know better than anyone. Know better than what? That sometimes the truth doesn't matter. I stared at her. Then why are you so afraid of the documents? Her expression changed. Only brief, but I saw it. Fear. The next morning, my attorney received a notice from Briarwood's legal team. They were requesting an emergency hearing. They claimed I was interfering with HOA operations. They claimed I was damaging their reputation. They claimed I was illegally withholding association property. Margaret read the filing twice. Then she looked at me. They're going all in. Good. She raised an eyebrow. You're not worried? I looked out at the old oak trees my grandfather planted nearly a century earlier. I've spent my life watching people walk into court, believing confidence was the same thing as evidence. I picked up the original 1927 deed. They're about to learn the difference. But before the hearing, Margaret received one final piece of evidence. A former Briarwood employee had contacted her. He had something stored away for nearly 25 years, something he was afraid to reveal. And according to him, it proved Vanessa Whitmore knew the property records were fake from the beginning. The courtroom was silent when I walked in. Not the comfortable silence of an empty room, the heavy silence that comes before people witness a fight. The hearing was held in the same county courthouse where I had spent nearly 3 decades making decisions that affected other people's lives. But that morning, I wasn't sitting behind the bench. I was sitting at the plaintiff's table, watching someone else decide my future. Across the courtroom sat Vanessa Whitmore. She wore a navy suit and held a stack of documents against her chest. She looked confident, almost too confident. Beside her were 2 attorneys from the firm representing Briarwood Estates. Margaret sat next to me, organizing our evidence. You ready? She whispered. I looked around the courtroom. I've been ready since the day they called me a squatter. The judge entered. Everyone stood. When we sat down, the Briarwood attorney immediately began. Your Honor, this case is about a property owner who refuses to acknowledge legally recorded boundaries. He walked toward the evidence table. Mr. Mercer has occupied association-controlled land for years without paying assessments or recognizing HOA authority. I listened carefully. Not once did he mention my grandfather. Not once did he mention the 1927 deed. Not once did he mention the development plans. That was intentional. They weren't arguing history. They were arguing paperwork. The attorney continued. The documents clearly established that the disputed acreage belongs to Briarwood Estates. The judge looked at Margaret. Counsel? Margaret stood. Your Honor, the documents they reference are exactly why we are here. She walked slowly toward the evidence table. We will demonstrate that Briarwood Estates relied on fraudulent records to claim ownership of land that was never transferred. The courtroom shifted. Vanessa stopped writing. Margaret presented the first document, the original Mercer deed recorded in 1927, then another. The county tax records showing uninterrupted ownership for 99 years, then another. The original Briarwood development plan. She placed it in front of the judge. Notice the boundary line. The judge studied it. The development does not include the disputed acreage. Correct. The opposing attorney stood. Objection. Those documents do not invalidate later transfers. Margaret nodded. Which brings us to those transfers. She held up the 1998 boundary agreement. The document Briarwood relies on. She paused. Your Honor, the signature belongs to Henry Mercer. The judge looked down. And Henry Mercer died 4 years before this document was supposedly signed. The courtroom went completely still. Vanessa shifted in her chair. The judge looked at the opposing attorney. Counsel? The attorney cleared his throat. We believe there may have been administrative errors. Margaret smiled slightly. Administrative errors do not resurrect deceased property owners. A few people in the gallery whispered. Then Margaret called her first witness, Robert Hale, a former project manager for Briarwood Estates, the man who had contacted us. He walked to the witness stand looking nervous. After being sworn in, Margaret asked, Mr. Hale, did Briarwood's leadership know there were unresolved title issues involving the Mercer property? He looked at Vanessa, then back at Margaret. Yes. The courtroom reacted. Margaret continued. When did they know? Before construction began. And why was construction allowed to continue? Robert swallowed. Because the company believed they could pressure the Mercer family into selling later. Vanessa immediately stood. That is a lie. The judge struck his gavel. Ms. Whitmore, you will remain seated. Robert continued. I attended meetings where they discussed making the property appear abandoned. Margaret stepped closer. Did anyone instruct employees to avoid mentioning the Mercer deed? Yes. Who? The room became tense. Robert looked directly at Vanessa. Vanessa Whitmore. The judge looked toward her. For the first time all morning, Vanessa no longer looked confident. Margaret returned to the evidence table. One more item, Your Honor. She placed a small folder forward. Inside was the original county survey map, the one with the handwritten note. Never approved, never transferred, never sold. The judge read it, then looked up. Where did this come from? Margaret answered, County Archives. The opposing attorney stood quickly. Your Honor, we request additional time to review this evidence. Margaret looked at the judge. They had 25 years to review it. The judge remained silent. He looked through the documents again. Then he removed his glasses, and everyone in that courtroom waited, because the next words would decide whether Briarwood Estates had simply made a mistake, or whether they had built an entire neighborhood on stolen land. The courtroom stayed silent for nearly 10 seconds. 10 seconds may not sound like much, but when your family's home, your history, and everything your grandfather built is sitting in the hands of another person, 10 seconds feels like an entire lifetime. The judge looked over the documents one more time. Then he looked directly at Vanessa Whitmore. Ms. Whitmore, before this court makes any determination, I want to ask you a question. Vanessa straightened. Yes, Your Honor. Did you or anyone representing Briarwood Estates verify the authenticity of the 1998 boundary agreement before using it to claim ownership? Her attorney started to answer. The judge stopped him. I asked Ms. Whitmore. The room became uncomfortable. Vanessa swallowed. Our legal team reviewed the documents available to us. That wasn't my question. She looked down. No, Your Honor. The judge nodded slowly. That is important. Margaret leaned toward me. She knows. I watched Vanessa carefully. For the first time since this started, she wasn't controlling the room. She wasn't standing behind paperwork. She wasn't speaking with confidence. She was realizing the documents she used as a weapon had become evidence against her. The judge continued reviewing the filings. Based on the evidence presented today, this court finds significant irregularities regarding the alleged transfer of the Mercer property. The opposing attorney immediately stood. Your Honor, sit down. The attorney slowly returned to his seat. The judge continued. The court finds no valid evidence that ownership of the disputed acreage was ever transferred from the Mercer family. My chest tightened. After months of being called a liar, a problem, and even a squatter, the truth was finally being spoken. The judge ruled that Briarwood Estates had no authority over my land. The emergency possession request was denied. The HOA was ordered to remove all unauthorized claims, notices, and property markings. But the judge wasn't finished, because the evidence suggested something much bigger. The forged documents were referred to the county prosecutor for investigation. Possible charges included document fraud, conspiracy, and unlawful property claims. Outside the courthouse, reporters were waiting. The story spread quickly. HOA accused of using fake documents to claim family-owned land. Neighbors who had once avoided eye contact with me began approaching. One elderly couple from Briarwood stopped me near the courthouse steps. The husband removed his hat. "Mr. Mercer, I owe you an apology." I looked at him. "For what?" "We believed what we were told." I nodded. That's how these things happen. Over the next several months, Briarwood Estates changed completely. Vanessa resigned from the HOA board before the investigation concluded. Several board members stepped down. The developer behind the expansion project faced lawsuits from homeowners who had purchased properties based on false representations about future plans. The proposed Briarwood Commons project collapsed. The road expansion never happened, and my pasture remained exactly where it had always been. A few weeks after the final ruling, Sheriff Thomas Reed stopped by my property. He parked near the old oak trees and walked toward the porch. "Looks peaceful again," I smiled. "It is." He looked toward the eastern fence. Funny how a piece of paper almost changed everything. I looked at the farmhouse. My grandfather used to say, "Land remembers." The sheriff nodded. Looks like it did. That evening, I sat on the porch watching the sunset over the fields. For months I had been fighting to prove something my family already knew. This was home. Not because of a document, not because of a court order, because 99 years of memories lived in every corner of that land. And no HOA rule, no developer, and no forged signature could erase that. A year has passed since the day the sheriff stood in my driveway and said 3 words I never expected to hear. "Good morning, Judge." Looking back, the fight was never just about 68 acres of land. It was about something much deeper. It was about the belief that ordinary people should not be bullied into surrendering what belongs to them. My family kept this property through generations of changes, economic struggles, storms, loss, hard times. But every generation added something of their own, a repaired fence, a planted tree, a memory, and that is what I learned. Property isn't just about boundaries drawn on a map, it's about the lives built on that ground. Today, I still walk the same paths my grandfather walked nearly a century ago. I still drink coffee on the porch every morning. I still watch the sunrise over the same fields. But now, every time I pass that old fence line, I remember one thing: never underestimate the power of the truth, because sometimes the people who appear to have the most power are only standing on a foundation built from lies. And sometimes, all it takes is one person willing to stand up and say, "This is wrong." Thank you for listening to my story. If you've ever experienced an HOA dispute, a property conflict, or a situation where someone tried to take advantage of you, share your experience in the comments. I want to know, what would you do if someone tried to take away the place your family called home for generations? If you enjoyed this story, make sure to like the video, subscribe to the channel, and turn on notifications for more unbelievable HOA battles, property disputes, and stories of justice. Because sometimes, the smallest piece of land can hold the biggest piece of your heart.